Same.
I'm shopping for books on Amazon and I get this prompt, like you may be interested in this. And that's how I learned it was all.
Algorithm. AI is great.
Exactly.
It's
And I said,
yes,
"They
I like
may
your
be
perspective.
interested."
Okay, well, let's get started here. Thank you everybody for coming. Welcome to today's panel on new directions in law and development. I'm Professor Francesca Bignami, and I will be moderating this discussion. After introductions and thank yous, I'll take a minute to set up the discussion, and then I'll hand it over to the panelists. We have an extraordinary group of scholars assembled here today, and I will be briefly introducing them in the order in which they will be speaking. So on my left here is Mariana Prado, who is Professor of William C. Graham Chair in International Law and Development at the University of Toronto Faculty of Law. Next to her is Katie Young, who is Associate Dean for Faculty and Global Programs, Professor and Dean's Distinguished Scholar at Boston College Law School. Rosa Celorio needs no introduction, but we should say that she is Associate Dean for International and Comparative Legal Studies and Burnett Family Distinguished Professorial Lecturer in International and Comparative Law and Policy. And on the end is, last but not least, Catalina Milos, or I should say Dr. Milos, who was awarded her SJD a few minutes ago. So each of the panelists will speak for about 10 minutes, and then we will have 10 minutes for Q&A. I will be keeping time, and after our discussion is over, we're going to go a little bit past 6 o'clock. We have a reception just over there in the book room, and everybody is welcome to attend. I encourage you to attend so we can continue the discussion and also congratulate our newly minted SJD here. Okay, so I also should say thank you. Thank you to the Dean's Office for supporting this event. And thank you to the Office for International and Comparative Law for all the amazing logistics that went into making this possible. So thank you very much. So now let me give a short setup for those of you who may not know what this field is. What is law and development? And since I teach comparative law, I actually teach it in my comparative law course, so I can kind of give you a very, very short child's guide to it. And so basically law and development, again, for those of you who are not familiar with the field, is premised on the intuition and the theory that one way of making low-income countries more prosperous is by exporting the right law to those countries. And this law can promote development. As the field was initially conceived, economic development. The first wave of scholarship and policy work came in the 1960s, and it mainly consisted of exporting American law to Latin America and other places in the global south. In the 1970s and 1980s, it went dormant for various reasons. It was resuscitated, the field of law and development, in the 1990s after the collapse of communism and the Soviet Union and the failure of the Soviet planned model economy. So therefore, at that time, the idea of markets and markets being, the path to prosperity really gained global currency. And so at that point in time, the so-called Washington Consensus took over. Western law on free market and political liberalism was exported to developing countries, and a lot of the exporting was being done by the international development banks that you see like just behind you. So there's this policy toolkit that was used and was exported to developing countries. And so I would call that the second generation. But that has come under a lot of attack recently, beginning basically in the global financial crisis in 2008. So it turns out that markets aren't so great, at least global capital markets aren't so great. So that was one big hit that this so-called Washington Consensus took. The other hit that it's taken is COVID. We learned that global supply chains don't work so well. So global markets also have that problem. And they especially don't work where part of the supply is coming to countries that aren't friendly countries, let's say. They're authoritarian countries that use global supply chains as strategic instruments. So that's another way in which the second generation of, I'd say, Washington consensus law and development has come under pressure. So the question is, what comes next? If we don't have Washington consensus, what comes next? And so that's what the people on this panel are going to be talking about. What's coming next? It's really that we see here the cutting edge on thinking in the academy on what kind of law and what kind of legal projects deserve attention and resources in the global South. So I will now pass it over to our speakers, and first to Professor Prado.
Thank you so much, Francesca. It's an honor and a pleasure to be here. We had the most enriching conversation this afternoon, which I think was a perfect exemplary of a law and development scholarship, piece of law and development scholarship. And I'm looking forward to continuing the conversation in this panel. And what I'm going to be talking about is a book that I published, came out in 2019, not to claim that this is the future of law and development, but I think it's a piece of the puzzle of the things we need to be think about in order to move forward. So let me just contextualize to you where the claim of the book is coming from. I think as Francesca has already mentioned to us, there was a lot of attention to markets for a certain period of time. The Washington Consensus brought that about. But shortly after that, there was an attention to institutions. So there was a lot of literature that came out saying that institutions matter for development. Some of these claims were attached to markets. We need to protect property rights and enforce contracts. But there are some other authors that were making broader claims. We need rule of law, we need independent judiciaries, we need functional institutions. And some of the authors that fall into that category are Douglas North with Institutional Change and Economic Performance. And there is a very popular book that some of you may have come across, Why Nations Fail, by Daron Acemoglu and James Robinson, where they say inclusive institutions promote economic growth, exclusive institutions don't, and those are the principles that should be guiding the way we look at institutions. So the World Bank developed governance indicators where they go around the world measuring how good are the institutions that countries have as a result of that. So these are all claims that are descriptive. When we look at our past, when we do quantitative regressions, as Daron Acemoglu and James Robinson do, we can determine that good institutions promote growth and bad don't. But then comes the question of how do we get good institutions? So the World Bank has sponsored, financed, and promoted a series of reforms in developing countries, so-called rule of law reforms, trying to make judiciaries independent, trying to create a bar, trying to make functional institutions, regulatory institutions, and most of these reforms have largely failed. So there is vast academic literature showing that. My colleague Michael Tribulco, together with Ron Daniels, who is now the president of Johns Hopkins, wrote a book called Rule of Law Reform and Development, where they survey all the evidence available and say it's not so positive. Thomas Carothers has done the same, and Eric Jensen and Thomas Heller have also written about failed reforms. So where does that leave us? It leaves us in a place where there seems to be robust evidence that institutions matter, but we don't know how to reform dysfunctional institutions. And this is where my book comes in. Basically, the question that Michael and I were asking in this book is, why are we trying to reform dysfunctional institutions when we can simply bypass them? So if you think of a coronary bypass surgery, there is a clogged artery in the heart. We don't try to unblock that. We try to go around it, taking an artery from somewhere else in the blood and restoring the blood flow in that way. So the book basically asks why we are not looking at the possibility of creating a parallel institution that performs the very same function of the dysfunctional institution and offers a choice to the users who can say, if this is better than the alternative, I'll choose this one. If it's not, then I will stick with the old institution, right? So this is the essence of the idea of a bypass. Once we have conceived of it, we started looking around. And actually, we're quite surprised to find out that there is a lot of bypasses happening already in developing countries. So what the book does is, the book is not trying to say we had a brand new idea that nobody had thought of. The book is basically trying to say, look, the policymakers in developing countries are doing bypasses almost on a daily basis. We are offering a concept that allows us to aggregate these structures, identify them, aggregate them, so now you can have a conversation between, for instance, people who are doing policy reform and people who are doing educational reform because they didn't use to talk to each other, just because they are using the same institutional structures, despite the fact that the details of what they are trying to do in trying to get police officers to be accountable will be very different from trying to improve educational services, right? So we try to show that bypasses are out there. We give one example that I'm quite fond of is a bureaucratic reform that took place in Brazil in the 90s in the state of São Paulo, where there was a very dysfunctional bureaucracy. Brazilians need identity cards, they need driver's license, and they had to stay in lines and spend a lot of time filling out forms and dealing with sometimes corrupt bureaucrats. And instead of trying to modify the system, the state of São Paulo in Brazil just created what is known as poupa tempo, which is saving time. And it's a very efficient place where you can get all the services. So the dysfunctional bureaucracy stayed there. They did resist a little bit the innovation because they saw that was a threat to them, but the resistance wasn't enough to prevent its implementation. And now Poupa Tempo took over as the primary provider of these services in the case of Brazil. So why I think this is a helpful way for us to move forward? I think it's a helpful way for us to move forward because we know that legal transplants, as Catalina helpfully articulated in her doctoral dissertation, don't work. So trying to copy and paste from rich countries into developing countries has failed repeatedly, right? But instead, if we can create structures that allow us to experiment, then we may be looking into something that sounds a bit more promising. And this is the last thing I'm going to say. The bypasses, in addition to moving the conversation from your judiciary needs to look like the Canadian judiciary to a conversation about what are the structures that may allow you to improve the services you're providing, the bypass also allows you to do experimentation. And this is a big, big component of the developmental literature right now. So the developmental literature, part of the authors have said, because we have tried reforms and they have failed, we don't know what we're doing and we need to do a little test drive before we can commit to a particular reform. So what the World Bank used to do, fly down to Brazil and try to reform the entire judiciary, which is a big judiciary in a big country, and then just to discover 2 years later and after a lot of money that it has failed, instead of doing that, you try to create a little bypass in one court and see if it works. And if it does, then you can try to expand from that. If it doesn't, then you shut down your bypass and you go about trying to think what else you can experiment with. So I think in addition to helping us think about structures as opposed to legal transplants, the bypasses create forum for experimentation, which is where I think a great deal of the law and development literature is going. So The book is available in the best bookstores near you, and if you have comments, questions, or examples of bypasses, please do and contact me, because I'm looking for writing more about what they have done. Thank you so much.
Okay, well, I'm going to speak about a field of study adjacent to law and development, which has always been connected, and that's the field of economic and social rights. We got to speak about different literatures as we were enjoying reviewing the dissertation of Catalina today, and it's interesting to see the connections between the two fields. If you believe that development is oriented to something more than economic growth or another set of indicators about what the society is achieving, but actually relates to human development and conception of every individual's ability to live a life they have reason to value, which is Amartya Sen's conception of development as freedom, then social and economic rights and development and law and development are much more overlapping than you would first think. But that's exactly what I study, rights to education and healthcare and housing and social security and food and water and sanitation. And I particularly look at the way they have become constitutionalized around the world, as well as the way they're part of the landmark architecture of the international human rights system. So I'm going to offer you thoughts about the progression of the field of economic and social rights as an overlapping field with law and development. And I thought I'd take my focus three kind of places in which I think important questions are being asked. I'm currently working on the Oxford Handbook of Economic and Social Rights with some 50 chapters with people coming at the field from every number of disciplines, not just law, but political science, political philosophy, anthropology, economists. And so I think that from an interdisciplinary perspective, I could say a lot more about different directions, but I'm going to keep my focus on the legal angle. So the first question, I think, which has become very pertinent to the human rights field, is a kind of trend in which we're seeing, alongside populist and authoritarian movements, an appropriation of the human rights discourse, which is no longer rejecting human rights as somehow below the level of importance, below economic security or efficiency or national security. But actually, we see a lot of populist movements appropriating the human rights discourse, no longer minimizing human rights as irrelevant, but actually seeking to articulate the truer version of human rights. This is a phenomenon that I've elsewhere described for the United States, in which I saw a type of appropriation going on under the Trump administration, when the Pompeo Commission established under the Secretary of State, Mike Pompeo, decided to re-elaborate what human rights should mean for American foreign policy. And in that move, the Commission was charged to look to the Declaration of Independence and the Universal Declaration of Human Rights to come up with a truer instantiation of human rights for human rights foreign policy. And thereby look to see that religious freedom, for example, or private property were the predominant human rights. Now, this is a move that I've described as human rights originalism because it looks backward to some landmark documents that we should very much vindicate or venerate, but actually look back, but we shouldn't simply arrest our interpretation of human rights at those documents. I mention that because this same trend of appropriating a human rights discourse is actually occurring in many other countries as well. And I leave that as an important signpost for what we look to when we think about what the right to healthcare or the right to housing or the right to education, the right to food, the right to sanitation means in various places when there are these appropriative moves going on. I don't want to say this is simply a right or left dichotomy, but we do see particular configurations in which religious freedom or the rights of the family or the rights of the fetus are elevated as truer human rights than other objectives. So that's an important area that is very contemporary and is really part of the human rights dimension of economic and social rights. The second question I want to put out on the table for my field of economic and social rights law is the engagement with crisis as a constant. And so I think we saw with COVID-19 that the world was dealing with a health crisis of global proportions in which day by day people were struggling to understand global supply chains, what was normal, what should be administered in a healthcare environment, what should be administered in a business environment. And there was a sense that the traditional doctrines that human rights law have dealt with to deal with crisis were becoming the mainstay doctrines. So I don't want to get too doctrinal here, but in economic and social rights law, we've seen constant financial crises occurring, the global financial crisis in 2007-2008 being the most recent one, in which a decision was made to engage with retrenchment on certain commitments in education and healthcare. And these retrenchments were justified on a doctrine of proportionality. And so to be a little bit doctrinal here, the doctrine of proportionality means that you can, in response to an important public interest, limit previously guaranteed entitlements in order to achieve those interests. Proportionality was used then to justify massive austerity cuts across Europe, and people became familiar with this kind of doctrine to understand nation states can be compliant with their human rights commitments and their economic and social rights commitments during a crisis in which certain moves can be made which we wouldn't otherwise expect. If that's the doctrinal standpoint, it becomes very concerning when crisis is becoming such a regular occurrence. I don't need to mention climate change or digital disruption or any other number of perhaps unpredictable occurrences that are occurring to suggest to you that proportionality then becomes a doctrine that doesn't give us much grounding when we're understanding what states can and cannot do in the name of human rights. So that's a doctrinal issue that's now on the table that I think is quite new to the field. And lastly, I'm going to go to your institutional point. I think we're seeing massive innovations around economic and social rights in the global south. And it's not so much a case of the rich countries exporting to the global south and expecting their models to work, but innovations are occurring around the separation of powers and the structure of public institutions that are being fed back into gridlocked or deadlocked institutional settings in the global north. And so one example I would use is a kind of wellspring of fourth branch institutions which have been created, which are not strictly courts, and neither are they strictly the executive, but are independent branches that are fielding particular questions, providing monitoring, providing accountability, and administering plans. And so these take the form of human rights commissions, ombudspeople, equality commissions. We're seeing a massive amount of these auditing bodies. These have been described as fourth branch institutions because they don't fit that three-part separation of powers that we're so used to in the global north. So one study I've done in Ghana with my co-author Raymond Ataguba at the University of Ghana Law School has been on a national development institution which would exist as a fourth branch institution which would administer national development plans. And so it would provide a kind of more independent mode of development policymaking outside of the traditional executive. Now this kind of defies our models of how development decisions should be cast, whether to entrench them or not. The constitutionalists would see that a lot of the public are clamoring for some kind of constitutionalization of particular goals. That brings with it all sorts of problems with courts assuming a very large role in implementing or enforcing particular rights, and courts then usurping many of the executive or legislative branches. And so this is a kind of interesting innovation that's been occurring, not because of any export of a successful model, but because of what is seen to be required on the ground. So that's a true overlap, I think, with law and development and the institutional presentation, but I just leave that idea of institutional innovation occurring within the global south and kind of defying global north expertise as one in which we're seeing economic and social rights, which follow this particular tension with courts being implemented. So I'm going to leave it at those three questions. I hope there's a lot of comment from the audience, but first let me turn to the next two panelists.
Thank you, Rosa.
Well, first of all, thank you all for being here. We've had this amazing afternoon, and I have to say, I'm kind of pinching myself right now because one of my favorite parts of my job is that I'm surrounded by these amazing scholars, and these amazing researchers, and today has been an example of that. First of all, many congratulations to Catalina. I mean, this is an amazing achievement, and thank you so much to all the scholars that are here, especially led by Professor Bignami. But I feel that I've been in a scholarship school this afternoon, and it's been amazing. And I just want to tell you, how much I admire all of the work that they're doing, the research work, not only on law and development issues, but also on human rights issues as well. So I just wanted to add just a little bit, some remarks related to the work that I do, particularly in terms of research in the human rights field. And one thing that's important to know about me is that I do this work with different hats, right? I'm in an academic hat, but I've also been a practitioner for a number of years. So a lot of my work, combines, a lot of those doctrinal elements, but also practical elements and policy elements. And I focus on 4 areas in particular. I focus a lot on women's rights and gender equality. I also focus on intersectional discrimination and indigenous peoples, and also everything related to the environment and climate change. And I also have a special lens on litigation, especially litigation that happens, before global and regional bodies. And I just wanted to share with you some observations of trends that I've seen, important components that are very important to keep in mind, especially when you're doing any sort of work related to human rights issues in this particular moment in time, especially if you're litigating cases, even if you're writing about human rights issues in general. And these are elements that are molding not only scholarship in the issue, but also challenging what we understand as international law when it comes to human rights, but also the work of many actors. One of the benefits I have in my position is that I interact with all these actors, that are working with human rights issues, non-profit organizations and governments, and the academic sector and international organizations. And there's a lot of thought-provoking issues that I just wanted to share with you today. One of them is, of course, related to women's rights and gender equality, and it's really interesting what Professor Young just said, because today, for example, if I were to tell you, about the standards on women's rights and gender equality, we have a robust set of standards. We have many judgments, many case decisions, we have constitutions, we have national legislation. At this stage, you can say that we have at least a basic definition of obligations when it comes to discrimination, when it comes to gender-based violence, when it comes to access to justice, when it comes to due diligence, and many other obligations. But today, it's practically impossible to understand what women's rights and gender equality really are in terms of issues and concepts without understanding modern times. And for me, that's a very important contention. So for example, what Professor Young said, we can't understand what women's rights are without understanding the COVID-19 pandemic and the legacy of the pandemic. We can't understand what women's rights are today without understanding the impact of climate change, the impact of the Me Too movement, for example, the impact of the digital world, the impact of everything that we're seeing in terms of sexual and reproductive rights, both progress but also regression. It's one of the areas where we're seeing the most dichotomies globally as well. And I think another aspect that's really interesting, for me at least, is very thought-provoking when it comes to women's rights and gender equality today, is that we have shifted, or at least shifting, from this world in which women and LGBTI groups, particularly, were more victims, they were beneficiaries of protection. And now we're talking about autonomy and leadership and participation. It's a very different optic, to the rights, of victims. Now we call them survivors. I mean, there's really been a shift of language and a shift of standards, especially when you look at that work of international bodies that I think is very interesting. And I think also we have a different understanding of equality now as well. Equality used to be in the binary. It used to be only men and women. It used to be a comparison. And we're really moving beyond, that element, or that framework of thinking. Now we're talking about participation and opportunity and leadership and parity, and this need for diversity and inclusion. And I think it's absolutely fascinating, right? I just want to talk a little bit about state obligations, because when I started working in human rights, and when you go to school, when you think of human rights, we have a whole new set of global and regional standards aiming to restrain, state abuses, aiming to restrain all these state actors. This is why we have, in many ways, human rights standards today. But at the end of the day, a lot of human rights analysis today is about non-state actors. What do we do with those non-state actors? And I'm talking about individuals, I'm talking about corporations, and I'm talking about a range of private institutions. And it's really interesting because when you look at the work of these global courts and regional courts, and even at the national level, we're trying to make decisions here. Do we give more responsibilities to states? Do we strengthen that due diligence obligation and we say you need to prevent, supervise, and regulate what non-state actors are doing? Or do you work more on responsibilities for those private actors, like the Ruggie principles? Do you strengthen, the terminology? Do you talk about obligations also when it comes to non-state actors? Do you break that state paradigm, right? Or do you also give more responsibility to state actors? I think it's probably a middle ground there. We're still trying to figure out what to do there, but I do think the due diligence standard, there's still a lot of work there in terms of giving it more content, when it comes to non-state actors. Climate change and the environment. It's amazing what has happened with the environment. I remember when I was at the Inter-American System of Human Rights, how much convincing we had to do to even convoke hearings on the environment and climate change and global warming. I still remember how difficult it was to convince the commissioners to convoke a hearing on global warming. And now everything is about climate change and the environment. So, of course, it's one of the fastest areas in human rights. We also have, of course, that has helped at the global level, these new resolutions, the Human Rights Council resolution, also the General Assembly resolution, confirming this right to a safe, clean, and sustainable environment, although we already had this confirmed at the regional level in a number of treaties, and what's really interesting and what I encourage you to do is follow the trends in litigation. It's amazing how much climate justice litigation is happening at the moment. We even have major United Nations bodies ruling on, climate change cases. We just had an amazing decision from the Human Rights Committee that's giving us lights as to where we're going, when it comes to the definition of state obligations, especially when it comes to that foreseeable harm. What is potentially foreseeable harm and what are states, mandated to do when it comes to adapt and mitigate to climate change? I think it's an absolutely fascinating area of the law, but I think we also are very far away from truly understanding the scope, of the impact of a problem like climate change on women, on indigenous people, on children, on older persons and persons living with disabilities. I think a lot of the analysis really should go hand in hand with what we have learned, with discrimination issues as well. I also wanted to highlight, just stop for a second and talk about indigenous peoples. It's really interesting how in human rights we talk about groups and we talk about minorities, and indigenous people, there's basically an estimation that there's 476 million indigenous peoples globally. Like sometimes we're not talking about small minorities, we're talking about major groups of the population that have this history of discrimination. And then you have this entire set of standards developed on behalf of indigenous peoples. We have this United Nations Declaration. We have a framework, at least a basic framework of understanding, around self-determination and consultation and lands and property, non-discrimination, culture, and the environment. But we have these huge voids in implementation. And this is one of the reasons why I loved Catalina's dissertation today. It's one of the best pieces of work I've ever seen on what does implementation really should look like, when it comes to human rights. think the area of indigenous peoples is one of the ones where you see the most implementation voids, even when you have that legal recognition, even when indigenous peoples are recognized at the constitutional level and the legislative level. You have huge implementation issues, and it's really that distance between the theory and the practice, and that's one of the most important issues to really address, when it comes to human rights. And I just wanted to end just mentioning the digital world. It's amazing what has happened with the digital world. If you would have asked me 7, 8 years ago, is this an important area of the law? I would have told you, oh yes, it's a very interesting area in international law. We have to develop it. We have to define better state obligations. But now it has become one of the primary areas of development. And I think it's very difficult to understand human rights today without understanding individuals as users, participants, influencers, and creators. This is a key facilitator of participation and leadership, but it's also a setting where huge human rights violations are occurring. We're talking about violence, harassment, hate speech, bullying, other forms of discrimination. And I think it's an area that there's a lot of opportunities to develop very strong international law, and a better definition of state obligations. We need to define key terminology. We have to define what those responsibilities are between state, and also non-state actors, especially social media actors, and many others. How do you address that digital divide, right? And those disparities in access? How do you address that transnational activity? And of course, the right to privacy is huge here. And how can technological progress be used to advance human rights? Amazing area of the law, but also very evolving, when you think of international human rights law. And I think there's more to come. There's a lot of trends, and I think the next 10 years are just going to be absolutely fascinating, when it comes to human rights, precisely because of what Professor Young was saying. We're living in moments of crisis, and we're living in current conditions that are really molding our understanding of how human rights are moving forward. Thank you.
Somebody's way here?
Sorry.
Should we move over there?
Thank you so much for all the people that came today, and also to the previous panelists. I think it's a great introduction, all what you said before, for the topic that we'll address, that is more like a case study, like the situation that is happening now in Chile. Well, today I will briefly speak about my SJD research topic, which is the equal implementation of economics and social rights in countries of the Global South, but especially in the rights to health and education. But I will link this broader topic to the recent events that happened in Chile. I don't know if you are aware, but early this month, a constitutional draft was voted, and it was rejected by the overall majority of Chileans. The draft was very progressive, but especially in terms of economics and social rights, but it was rejected, as I said. I think that this experience it's very enlightening for other countries in the Global South, and also to the field of law and development more broadly. But before addressing this case at length, I want to mention why I think it's important to speak today about the equal implementation of economics and social rights overall in the world. Well, developing countries are struggling with the effects of the pandemic, the inflation, also the broader effects of climate change. And the truth is that now a larger part of the population has more troubles to meet ends meet. And in this context, like having access to high quality services in the areas of education and healthcare could be pivotal for easing inequalities in those countries. For low income countries, having access to these services could be a huge difference in quality of life. And for middle income countries like Chile, tackling these inequalities it's a growing concern in the population, and an issue that may be key to maintain the democratic stability
of countries such as Chile. But how to achieve these systems where you have delivery systems that are more equal, as already Professor Prado said, and also Professor Young, it's not so clear how to do that. And previous experiences of transplants have shown that many times when you try to apply a system from the north in the south, the process maybe end up not being very successful. And what is becoming more clear is now is that there needs to be a process that is do it with caution and with careful consideration of the economic, the political, and the social aspects of each country. As I said, I will speak today about Chile. Chile went through major market-based reforms during the 80s, while the country was under the Pinochet dictatorship. The country transitioned to a democracy in the 90s, and since then had an explosive growth in which a bigger middle class was built. Some legal reforms were done during the 90s and the 2000s, where the idea was to make more equal the services that were delivered in the public and in the private sector. But these reforms did not alter the divide under which the poor were accessing public providers and the affluent and a part of the middle class, the private sector. These differences, among other reasons, over time generated dissatisfaction in the general population. In 2019, like a few years ago, massive protests in Chile led like the political establishment to create a participatory process in which the Constitution of 1980 will be rewritten. A constitutional convention wrote a draft that was very progressive, as I said, in terms of rights, but it was rejected early this month by 61% of the population. And this experience left many, including myself, wondering what really happened. I will not explain here all the complexities and innovations that the new constitution will have brought to the country, but instead I will address what this new constitution will have mean in terms of changes for education and healthcare. And here you can see the two different constitutional texts. And the main change was basically on the role of the government, how it was seen. In the Constitution of 1980, in both rights, there was this element of choice, which required to have public and private system in both sectors. The constitutional draft voted early this month would have given more relevance to the role of the state, but it did not close the door for private providers to participate in it, as some in the Rechazo campaign were campaigning, were saying basically. Here you can see some slogans used by the Rechazo campaign, where Rechazo means reject, by the way, like reject the new draft. Where, for example, the fear of longer queues at hospitals was used as an argument to oppose the new constitutional draft. And basically, the idea was that this new constitution will debilitate the private sector, and this will mean that the collapse of the public sector. It's really interesting how the Rechazo campaign used the desire for having like changes in education and health to oppose the new constitution, while the whole intention of the new draft was to materialize desired changes in these two areas. Well, I think that this experience at least provides two lessons for future reforms in this area of rendering economic and social rights more equal. The first one is that allegedly the middle class, at least in Chile, is used to have access to these services in private providers, and then they surely don't want to lose this option of having these services available in the private sector, even though, as my research showed, in many times these services are very expensive and also not suboptimal in terms of quality. But the truth is that in several sectors, the public sector is not trusted to be an alternative to deliver high quality services. And this needs to be considered for any country that really wants to move forward to make the access to the services more equal. Also, I think that this experience shows that it's very difficult to roll back the business sectors once you have opened some areas of the economy to the market, and I think there needs to be a really thoughtful design of transitional periods and public-private partnerships to have agreements with the business sector affected for these changes to be successful in countries such as Chile. What egalitarian models such as Ontario, Canada, the other country that I analyzed in my research shows is that the middle class needs to be committed to the egalitarian scheme for the scheme to be successful. And this means that the services provided by the public sector or publicly funded needs to be high quality and attractive for almost everyone. I also think that this system should not be closed to the participation of private providers. Rather, each sector needs to be very carefully regulated in at least the 3 areas that I studied in my research, which are how you allocate those services, how you decide who will have access to which services, also how do you ensure that the access to the services is affordable, and how you make sure that the quality of the services is the right one. What my research has shown is like there is a need to take into account really seriously the laws and regulation that define each of these issues. And this means like taking into account in one side that there are limitations that come from having scarce resources, and also on the other side to also assess how you address the issue of the high quality demand, the demand of the public to have higher quality services. I would like to finish by saying that what happened in Chile does not mean that Chile nor other countries in the global south do not have the desire or the need to move towards greater equality. Rather, I think it exposed the complexities of making this reverse path in areas that have already been open to the market. And I think that this experience showed that there is a need to acknowledge the fear of the majority of the population regarding how a new setting to address access to rights such as health or education could really improve the services that they receive every day. I think the issues addressed here give some nuances to address the problem of tackling inequalities in developing countries that I think could be also very useful for the broader field of law and development. Thank you very much.
So we started a little bit late, and we will have about 10 minutes now for Q&A before we move to the reception where we can have informal Q&A. But I would welcome any questions you might have or observations from the audience. Please, yes.
Sorry, I'm laughing because I always have a question. If I could just be a typical academic for a second. I see that the presenters refer to economic and social rights. I wanted to know what you think of economic and social vis-a-vis socio-economic, because especially in a developing country context, we often refer to it as socio-economic because we believe the two can't be separated from each other. There can't be complete fulfillment of social rights if you don't also have fulfillment of economic rights. So that's why it's often just referred to as socioeconomic. In fact, we've totally done away with almost economic and social because the two go hand in hand. So did you deliberately do that, or was that just a way that you referred to both? I'm just being a typical academic.
Okay. Do you want to answer, Catalina, on your choice? Yeah, no, it's a huge, long debate, and at the time of the Universal Declaration, it was understood civil, political, economic, social, and cultural, and it's such an artificial categorization in many ways. Education, it was a big debate. Is it a civil right, a political right, or a social right? There are various kind of genealogies of each of these, but the international system denominated them, which became significant when the Universal Declaration's successor instrument was split into two treaties. And so civil and political were in one treaty, economic, social, and cultural were in the other. Economic was seen to refer to labor in particular and property in ways that social rights people thought should be actually about them. And, so I can absolutely understand why South Africa, for example, in its constitution refers to them as socioeconomic. It's actually a better classification system. But in terms of the international human rights language, it's still economic, social, and cultural. And so knowing that they blend into each other in interesting ways, but knowing that, I guess, the official UN doctrine is indivisibility, that you can talk about economic and social rights, but you recognize they're interdependent and indivisible, and so that's a response. But in my own work, I've chosen to follow the economic and social rights demarcation because it made sense with a lot of my references to always group them together but not merge them, as that was already seen to be a more domesticated concept. But I completely take the point that these categories defy logic sometimes, although they have their histories.
I don't think they necessarily defy logic. It's just a different framing would suit different contexts. So it would make sense that you say economic and social would be separate in the international field if economic means something else. So if you mean to distinguish it, then economic and social works. So
Unfortunately, it doesn't, because some people write about economic rights, and in the US, there's often been a descriptor of welfare rights, and so people have tried to unleash or actually disrupt that discourse, and they refer to them as economic rights without including the social. Yeah. I don't know why that choice was made. So you have people talking about social and economic rights here, or economic rights. So it actually sometimes does defy logic. I don't want to suggest it's actually more neat than it is. But your choice, economic and social rights, that terminology, why did you choose?
I think it is the mostly used in our field. But I agree, like there are some countries that use the other way, and I guess it's more about each country like making a decision about how they want to refer. But if you go back to international human rights, like what Professor Young said is true, like it's the way that is framing international human rights, like economic, social, and cultural rights, and then on the other hand,
Yeah. I was just wondering about it because as a lawyer, wording is important. So if you change wording, it changes the perception of what the right is you're trying to promote. So I think that's why the question popped up, because I was thinking, obviously, with the South African brain, socioeconomic versus economic and social, it creates two different, objectives in my mind. Maybe I'm just being overly lawyery.
Fernanda? Yeah.
Thank you. I have a question for Mariana, and the idea of the bypass. That sounds very similar to the transplant in terms of what if the bypass doesn't work, the person dies, and even though you say it's a little experiment. So some of the critiques to legal transplants where the literature is pushed to call it legal transfer. And I really like Ralph Michaels' one size fits all to understand that it's really not so much the abstract rule, but it's like the decontextualization of an abstract rule and the recontextualization in another setting. So for your example with the bypass, I'm wondering, there's also merchants of bypass there, just like there are merchants of transfer, they're very problematic. And who is your group? Where are you going to take the implementers of the bypass, the ones who are going to be your experimental group that is going to work with this shadow institution? Where do they come from? How are they trained? Are they locals or not? I see lots of dangers too in this bypass position. And finally, are we in a new, especially you've written a lot, Mariana, on land development, is this a new, we've heard from Katie about populism, and I'm wondering, are we going back to a model of import subsidization, industrialization, that in which perhaps your bypass is a minimalist intervention, that countries that are going back into a form of slightly protectionist or more value-based trade are more interested in, this is more sellable, if you want, than a transplant. So functionally, it works more easily. Thanks.
Thank you. Thank you. Should I respond?
Yeah, please.
Thank you, Fernanda, and it's so nice to see you again. So let me take the first point, which I absolutely take your point. So let's keep with the medical analogies, right? So in a medical transplant, you're normally taking an organ out of the body and putting a new one in place, right? And whereas the bypass, you're sort of changing a feature in the system, but the organ is still there. So I think I will use this to say, I think it's less of a radical change, and in that sense, maybe the health risks involved might be proportionally less, might be small, right? But that being said, I take your point. I think Gunther Teubner has a text that I love where he called legal transplants legal irritants, because it's not about whether they're going to work or not. It's about inserting something new in the system and then seeing how the system reacts